is Ben Miller, and I'm a senior attorney with MNK Law, where we help businesses navigate the challenging legal environment they face today. Before we get into today's video, please do not forget to like, comment, and subscribe to our channel for more resource videos like this one. In this video, I'll discuss a few important tips to remember when negotiating commercial lease agreements. Number 1. Tenant improvements. This term describes work that is performed on the premises to be leased for the purpose of making the premises suitable for the tenant's occupation and use. The lease agreement should clearly define who is responsible for performing tenant improvements and who is paying for tenant improvements. Landlords who agree to perform and front the cost of tenant improvements may seek to recoup this expense by increasing the dollar per square foot rate upon which rent is based, or by incorporating the cost into operating expenses, which are then charged back to the tenant. In addition, the lease agreement should provide for what happens if there is an issue with tenant improvements. Many lease agreements provide that the tenant will take possession of the space as is, which means that the tenant may not have any recourse if tenant improvements are not properly completed. Tenants who want to avoid this should include a specified period of time after move-in to notify the landlord to fix any potential defects with the tenant improvements. Number 2. Assignment and sublet rights. Assignment and sublet rights allow the tenant to assign or sublease the premises to a third party. The need to exercise these rights can arise under many circumstances, and it is common for a landlord to limit these rights or condition them on the landlord's approval. A tenant with broad assignment and sublet rights will be able to pass the lease obligations to a third party if necessary and limit its liability for doing so. If the lease agreement requires the landlord's consent for any assignment or sublease to a third party, the tenant can counter this by including a provision stating that the landlord cannot unreasonably withhold consent. Number 3. Repairs and maintenance. Poorly worded or ambiguous language under these lease provisions often lead to disputes between landlords and tenants. It is important that landlords and tenants clearly identify what repairs and maintenance are included under the lease. Landlords will seek to limit their repair obligations and pass any such costs to tenants. Conversely, tenants seek to limit their obligations to non-structural elements and exclude big-ticket items such as a roof. It is critical that the lease plainly outlines the scope of each party's responsibility for repairs and maintenance. Typical landlord obligations include common areas, building systems, roof, exterior walls, elevators, foundation, parking lot, or the garage. Typical tenant obligations may be limited to the rented premises and the HVAC system within the premises. Commercial leases also frequently allocate building and repair maintenance costs as operating expenses to be paid by the tenant on a pro rata basis. Operating expenses can include a wide variety of items, and tenants should request that the landlord provide a projection of the expected operating expenses to be charged to the tenant under the lease agreement so that the tenant can budget for the additional cost. That concludes this overview of several tips to remember when negotiating commercial lease agreements. For more information about commercial lease agreements, visit our website at mnklawyers.com or contact us at info@mnklawyers.com. Thank you and see you on the next one.